Hi, I'm attorney Chris Rike, and in this video I want to talk about the things that attorneys can and cannot do for their clients. Fortunately for most people, they don't interact with an attorney on a regular basis, so sometimes it can be unclear what exactly are the boundaries of what your attorney can do for you and what they can't do. So first I want to talk about some of the things that an attorney can do for their clients. Primarily, an attorney can be an advocate for their clients. They can craft legal arguments, whether it's in writing or making those arguments in person in front of the court. An attorney can often appear in court for their client so the client doesn't have to show up. This would typically be for non-evidentiary hearings like a pretrial conference or a status conference. If there's a trial, of course, where there can be testimony and evidence presented, then typically the client is also going to have to be present. An attorney can enter into agreements for their client with the prosecution as well. Of course, the attorney needs to get the consent of their client before doing this, otherwise that would be a major ethical problem. But an attorney, if the client is not there, can enter into that agreement with the prosecution as long as they have their client's consent. Another useful thing an attorney can do is advise you on a course of action based on that attorney's experience with these types of cases. A lot of times for our clients, this is the first time they're encountering this particular situation or a particular problem, whereas we do this every day, so it's possible we may have seen that same problem dozens or maybe hundreds of times over the course of our career. So we have a little background to advise on what would be a good course of action. An attorney can also request discovery, request evidence from the prosecution. So one thing, we know what evidence is probably available in a case, and we know to ask for it. Prosecution is not always forthcoming with evidence, especially if a defendant is self-represented. The prosecution knows the defendant doesn't really know what's going on typically, and they seem to take advantage of that and will not make full disclosures. They'll just make the bare minimum disclosures to their client. The other thing we can do as part of that discovery process, we can interview the police officers or other witnesses in that case so that the defendant does not have to do that. Sometimes that can be intimidating if you're conducting an interview with the police officers that issued you the ticket, because there's that power differential. Whereas the attorney, we are perfectly fine interviewing cops or whoever we need to get the information for your case. So now I want to talk about some things that attorneys cannot do for their clients. We cannot lie for our clients. We cannot let our client lie if we know that they're lying. We can't unreasonably delay the case. We can't make up reasons to continue the case that have no basis in reality. We can't obstruct the process of these cases. We cannot meet in secret with the judge to get a better outcome. We cannot bribe the judge. We cannot bribe the prosecutor. We cannot make backroom deals with prosecutors and judges. It's not like the TV shows. Everything is actually pretty above board. There aren't any backroom deals or secret handshakes that are involved. All the attorneys, we may be familiar with how a particular judge or prosecutor operates, and that can be useful, but there's no shady stuff going on here. Covered it also earlier, we can't accept settlement on our client's behalf without the approval of the client. So an attorney is not going to be making any deals without the defendant, without their client being included in that decision-making process. Two other points I wanted to cover. I wanted to talk about attorney's fees and outcomes. This comes up sometimes where, sometimes in a case, the facts just are not in our client's favor. That happens. Sometimes the facts are bad and the prosecution's unwilling to work with us, and it looks like we're not going to get the outcome that we want. Sometimes a client will try to offer us more money as if paying us more will change the facts or the outcome of their case. As if paying the attorney more money will suddenly make us, oh, now we're going to start working and now we'll get the outcome that we all wanted. This is not how it works. We always want to get the best outcome possible for our clients, and we do everything we can to get that outcome. More money is not going to change that. Plus, if an attorney did that, that would be a serious ethical violation to take more money to change the outcome in a case. This kind of is similar to the rule that attorneys cannot do criminal cases on a contingency basis. So in other words, we cannot alter our payment based on the outcome of the case. Whereas we can't say we'll charge $1,000 if we lose, but you'll pay us $5,000 if we win. Again, major ethical outcome. Also, it doesn't change the amount of work that an attorney has to do on the case to get to the end of the case. Just sometimes we don't get the outcome that we want. Often we do, but every once in a while we do not. The other thing that seems to come up with some frequency, and I think this is a problem with media, TV shows and movies. We've all seen a movie like My Cousin Vinny, or maybe a TV show like Matlock or SVU, Law and Order. There are no surprises in a criminal case in real life. In these TV shows, you see the defense attorney shows up on the day of trial and they set up their witness perfectly and they get him to say something, and then they whip out a surprise piece of evidence that makes their case and destroys the opposing side. This doesn't happen. In real life, both parties have to disclose all the information well in advance that they want to use at trial. If they don't disclose what they want to use at trial, then they don't get to use it. Those are the rules. So there are no surprises at trial. That's part of the reason why a lot of cases don't go to trial, because by the time we have exchanged all of the information, both sides have a really good idea of what's going to be presented at trial and how it's probably going to go. And disclosing all that information, exchanging all that information, facilitates resolution without a trial. Those are some of the things that attorneys can or cannot do. By no means an exhaustive list, but that does cover the high points.